At great cost to me, in this eviction battle that I'm in, I'm going to take the time to teach you about real estate law as far as your residential leases, contract law, and fraud. We're going to talk about my case, what the building is trying to do, and what my legal side is up to in order to get to the end of this thing. And hopefully by the end of this, you're going to be much more prepared to sign your leases and to negotiate your leases. This is huge. It's costing me thousands of dollars to give you this information. So before we even get to my title reel, subscribe, because if you're going to put me through this to learn, you might as well subscribe to my channel right now. So my name's Sean Rocky Geach. This is Airbnb Automated, and let's teach you some contract law. All right, welcome back, Airbnb family. Today, I just got out of eviction court. It didn't go how I thought it was going to go, and it definitely did not go how you guys expected it to go. I'm certain of it. So I'm going to hit you with a lot of stuff right now, and I'm going to try to keep it concise. Also, the last time I was in this building, I did a video about the 3 things that you can do to market your Airbnb off Airbnb to get more leads. And the audio quality was trash because it's really tough to get good audio in this building. So hopefully the audio is better. If the audio is good enough, you can hear me. Mic check, leave me a like. Mic check, like me if you can hear me. But anyway, to the topic. So let me tell you about the negotiation. First off, where did we begin? My real estate agent and I approached a building. We wanted 12 leases at a building, and we negotiated 3-year leases with 4 months of concessions. Second month free, 12th, 24th, 36 months free. We then negotiated our scheduled onboarding for all the leases, and we executed lease number 1. So lease number 1, they gave me my lease concession, they gave me my lease. My lease did not have any provisions in it that prevented me from running my business, which of course is important. Inspected the lease, everything's chipper, we sign up, we're good to go. I moved my property manager into that apartment as we start to get boxes from Amazon and everywhere else getting ready to launch. So we pick up 1 unit so that we're paying rent for 1 spot, but then we can use that space to fill up with everything and start staging. And then we activate 4 more leases, move all the furniture in that day, and then do. So here's where it starts to derail. We go to pick up our other 4 units, and there's a delay. The lawyer did not give management, so the owner has a lawyer, and there's a management company that feeds the leases to the leasing staff. They did not feed the leases to the leasing staff in time, so there's been a multi-day delay. We placed a furniture order that was about to be we're going to deliver 4 really nice sleeper sofas, and we spent all this money on other stuff that we need these keys. So I'm bugging property management for the keys. I'm like, I need keys. They're like, well, you need to sign the leases before we can give you the keys. I'm like, okay, sounds good. Give me the leases. They're like, well, hold on. We're waiting on them. So they did not provide me my 4 next leases until 30 minutes to an hour after the furniture people were at the building waiting to unload the furniture. So I meet with the building to get the keys because the furniture people need to get let in. We finally get the documents. Part of them is electronic, and then because everything was rushed, those lease concessions and other documents still had to be done on paper. So I'm signing with a representative of the building some documents on paper, and I'm signing the core parts of the lease electronically. Getting these both done wicked fast, get the keys, we start setting up everything's good to go. We then very shortly later get a cease and desist order from the lawyer that wrote the contracts, right? Really weird, stating that you cannot list your property on Airbnb. Well, first off, we're not even listed yet. There's another person in the building that is listing on Airbnb and has been for a year, and we're still setting up our properties. So I say, hey, we're not even live, taking guests yet because we're still setting up the properties. But we also negotiated our terms, so we're going to be marketing the property, and we have right to. But we're currently not doing anything you're telling us not to. So let's talk to the owner and see if there's a misunderstanding. Trying to be mutual here and make sure that if there was a mistake, we can come to terms. That was the last I heard of that. Then the owner fires the management company and the leasing staff that I negotiated with and brings in Greystar. Greystar picks it up and says, hey, you have an eviction that we're supposed to be pushing you through. And I'm like, I think there's a misunderstanding. Let me walk you through it. So the regional director of Greystar and I and the property manager, the new lady, we all sit down and talk about this. And they come to the understanding that we're not a regular resident. We are an LLC who signed the leases. And they're like, oh, okay, well, let's go talk to the owner. Sounds good. We actually work with another company, Sonder, all the time, and they have the same business model. So we understand. We're good. Moving on. A month and a half later, get a judgment or documentation, like a petition or pleadings. I get a copy of pleadings for an eviction petition while I'm in Costa Rica, right? So now they're having me show up today for court. So I lawyer up, and we go through the whole process here. And here's where we're at. Here's what we discovered. And we found this out while I'm sitting across from their lawyer. We discovered this in the moment of a negotiation, because this is wicked. So we signed our first lease. I inspected that first lease. That delay, the lawyer, he wrote in language that was not agreed upon during our original negotiation. He not only put Media Press Promotions, which is my company that's been signing these leases, as the resident or as the leaseholder, but he wrote me in under it as an added resident/leaseholder, and I did not personally apply for residency. I did not apply to stay there. So he added me in improperly. That was not part of our negotiation. He then also added in the use of premise clause that we cannot advertise the building, right? We cannot advertise on any services, Airbnb, VRBO, or more, right? All these. So what he effectively did was kill our leases, right? Saying, okay, you can have these extra 4 leases, but you can't advertise or do anything with them. And that's kind of where we were. So what does this mean for you? First, you need to know what a contract is. So let me post a screenshot. Mutually beneficial agreement. Each party must agree and accept the contract and its components. Okay, first off. 2, consideration. That the contract is mutually beneficial. Both parties must recognize the benefits from the contract, that they both are receiving benefit from the contract. Obviously, you must be legally able to sign a contract, it must be lawful, and it must be written when it's real estate law. So these are the basic elements of a contract. You could argue that there's more. So what's really tricky about this is you can argue that if somebody gives you a contract that you do not like, and you sign it under pretenses that were not favorable to you, that you can argue against this. So we're going to talk about fraudulent inducement next. Fraudulent inducement is where somebody, through fraud of contract, like they can write into a contract, they induce you to do business against your will because you were not aware of this inducement. So there's 6 aspects to fraudulent inducement in order for it to be argued. Let me pull it up. I actually sent this to my lawyer. So, fraudulent inducement. This is how to sue for damages. That's a different one. This is fun. I'm doing all this research as we're talking. So, let's see if I can put this up too. I'm going to screenshot this for you because I think you guys would like it. So the party in question must have made a fraudulent misrepresentation of the facts. 2, the misrepresentation must be material to the transaction. 3, the perpetrator of the fraud must know that the misrepresentation was false. The perpetrator who made the misrepresentation, this is number 4, with the intent to persuade the victim into agreeing to the contract. And then 5, the victim relied on this misrepresentation. And 6, the victim would not have agreed to engage in the transaction if he or she knew the truth. This contract, if I knew that my name was on the contract, not just my business, I would not have signed those leases. I was not personally guaranteeing these 4 leases. That's 1. So that alone was fraudulent inducement. He fraudulently induced me into the contract. And the argument for me signing it, then this is the thing that you have to argue now, is that when I signed it, I had to be in a situation that was unoptimal, or just not optimal for me. So let's open up this one and see if I can get you a screenshot of this one too. Man, I'm giving you guys everything right now. This is heavy stuff. Okay, so terms. Misrepresentation. So something that is not in line with facts. 2, fraudulent misrepresentation is a false statement that is known to be false or is made recklessly without knowing or caring whether it is true or false, and it is intended to induce a party to detrimentally rely on it. Negligent misrepresentation is a careless or inadvertent false statement in circumstances where care should not have been taken. Material misrepresentation is a false statement that is likely to induce a reasonable person or to assent, or that the maker knows is likely to induce the recipient to assent. That's a really fun one. Duress, an unlawful coercion used by the stronger party to induce the weaker party to enter into a contract by threatening the weaker party with financial harm. So, duress can be argued here. And how do we argue duress? They delayed providing me the contracts to the point where I had business that I struck with supplier. The supplier was supplying me furniture that day. And if I did not get the furniture that day, I would have lost $1,500 in delivery fees, and the furniture would have went away. We would have had to have it re-delivered at a future date, which means that we would have lost more business because there would have been a delay in our setup time. So we could have lost $1,500 plus opportunity costs, which because of this forced me to act too quickly in order to get these contracts finalized, in order to obtain my keys to complete our business function. And so signing those leases without review, which of course you can say, Sean, that's so dumb of you. Why did you sign 4 leases like electronically while signing things on paper and not review those leases? Well, because when you go back to the contract terms here, the contract must be mutually beneficial, and there's no mutual benefit in me signing a lease that says you cannot Airbnb your space or advertise your space on lodging websites, because our business model is to make a place ready and then to market it. And if I sign a lease that says I cannot market the property, that is something that I would not sign. That has no benefit to me. I'm just picking up the liabilities of rent. There is no value because those properties are not for me to stay in. I do not need them. I do not need 5 apartments or 12 apartments for me to live in 12 of them. There's no way to argue that. So, with that said, we are making the argument that the first contract was the correct contract. The concession agreement was the correct concession agreement. That we have, we have written communication, volleys of emails back and forth between all parties, showing that this is what was agreed upon initially, and the owner knew, and that we struck a deal for 12 apartments under this agreement, and that every lease following should have fallen under that agreement. So when the lawyer wrote in new language into a lease and did not let us know, that new language violated our original agreement. He snuck in fraudulently language that we would not have agreed to, and thus when I signed the extra leases that we signed, they were supposed to be duplicates, right? And overall, the leases look very much the same, right? So we signed what was supposed to be duplicate documents just for different units because we already agreed on all units in one stroke. So all 12 leases should have been the same exact leases, just with planned different start dates. And they changed the agreement on us. So that's where we're coming from. Now, what did we do in court today? Aside from knowing this now and starting to formulate our plan and how we're going to take our line of action, we could have taken this to court today and won. Right? We could have just taken it, shown the communications between us and the management company that was terminated, show the original lease, and we could have made our fraudulent inducement claim, and we could have went through with it immediately and won and not been evicted. But here's the problem: is you need to have a plan in these situations. It's not just what you want. Right? It's not just what you can do. It's what is your plan? What do you want from this? We have a non-cooperative agreement with the building now, right? That building does not like us anymore. The owner doesn't like the deal that his management team agreed to, and so he wants us out. He's putting pressure on Greystar. Greystar does not want that pressure. Greystar does not want us there if the owner is going to be on their tail. So they're going to be constantly looking for things to have problems with. We are no longer able to have a mutually beneficial relationship with that building, so we need out, right? We could win this court case, but that doesn't give us a safe exit from the building without weird further litigation and tying us up. So we need to now decide what is it that we want. And so we have continued it for a month. And this allows us to speak with Greystar, speak with the previous management company, the owner, if we can ever get that person on the phone, or to respond to a single email, and come up with something that we think works for us, where we don't take unreasonable loss, and we can move on from the building without having to deal with these parties ever again, and everybody can move on happy. So, and that's the fun part, is we could battle this and win it, and then end up in a contentious arrangement with the building for years to come. But that's not good for business, is it? No, it's not. So don't win an argument for the sake of winning an argument. That's not why you'll be successful. You won't be successful if that's your whole point, is just to win arguments. Approach all negotiations with a strategic mindset for outcome. So if you have questions, feel free to leave them in the comments. Hopefully you like this video, because this is some way cool stuff. way cool stuff, and this will rarely happen. This is a situation of fraud, and we are in a sticky spot because somebody tried to pull a fast one on us. So that's fun. If you guys stay tuned, of course, I'm going to give you more. Obviously, September is when my next court case for this is. We'll probably have it negotiated before then, but I'll let you know kind of what we're going to do. So with that said, I'm going to get back to doing my homework, and thank you for watching Airbnb Automated. I will see you on the other side.